All right, that boy Cuff Boys dropped another video, y'all, about the YNW Melly murder trial. Last thing that we heard about is that the lawyers asked the judge to make the prosecutors show the reason that they got a reason to go through one of his lawyer's phone. So basically, his female lawyer, they went through her phone, they subpoenaed her phone, then they kind of forgot the reason they even subpoenaed the girl phone. And now the lawyer's like, hell nah, y'all finna tell us the reason y'all subpoenaed her phone. And the judge say, hell yeah, you damn right. They better show the reason they subpoenaed the phone. Now here it goes. It sounds like they had to January 14th. Right now, it is January 19th. So 5 days ago, they were supposed to submit why they subpoenaed her phone. They were supposed to give all that information to the courts and the lawyers. And if you ask me, I feel like they failed to do so. And that's what this video say. So, yeah, let's see what the fuck going on.
14th for Melly's defense lawyer's Apple account. And take a wild guess if the state handed it over. Of course not, because they filed a memorandum of law and a protective order request. The state basically asserts that Raven Liberty can't be Melly's lawyer anymore. And they straight up disobeyed the judge's order. So he's going to be livid. I'm going to read the full document here. Hit subscribe. Here we go. Our first thing we got here states a memorandum of law regarding attorney conflict. On December 27, 2024, defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18th, 2024 by Apple that on December 13th, 2023, that her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. Monday, January 6th, the Honorable Court heard the defendant's motion and the court ordered her to hand over the search warrant. That's what he did, right? On January 6, 2025, the state filed a motion for rehearing reconsideration to compel disclosure of Apple search warrant related to attorney Raven Liberty. Within this motion in paragraph 11, the state mentions that regardless of the details of the investigation, Ms. Liberty has the ethical obligation to withdraw even if the defendant were to waive the conflict. So straight up, the state is saying she needs to withdraw and not be his lawyer anymore. Kind of crazy, right? In U.S. vs. Pizona, 2006, the court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified notwithstanding defendant's desire to waive. If the activity for which the attorney is investigated is substantially related to the charges against the defendant, disqualification is necessary, notwithstanding the defense waiver. At one point, they said it wasn't related to the charges against the defendant. Stewart even pointed that out. He said, is it related or is it not related? To the judge, I don't know if we ever got an answer or not. Well, no, she said it was related to Melly, but not the other charges. It's about the witness tampering. On Tuesday, January 7th, the Honorable Court entered a written order ordering the state to provide a copy of the search warrant to the defendant to determine his potential conflict over the state's objection. Yes, and you should hand it over, right? Let me guess, you're going to find some reason not to, eh? Over the defense objection, this Honorable Court ruled it would review the search warrant camera for potential redactions. During this January 7th, 2025 hearing, this Honorable Court spoke to the defendant about how it was his decision alone, to determine whether to keep Ms. Liberty as a counsel despite the conflict.
That is what the judge told Melly. You feel me? He was basically telling Melly, bro, you got the opportunity to let us know if you want to keep your lawyer or if you don't. My opinion, I think Melly is going to keep his lawyer because I don't know what they found in her phone or what they was looking for in her phone. I assume they was basically trying to see if she was tuning ass over. You feel me? With all due respect, I mean that in the most respectful way. Because what else are you going to find going through a female's phone who possibly got personal stuff in her phone? She probably sending feet pics, booty pics, every pic on earth. Y'all really just evaded her privacy, and hopefully there's a reason behind it. As a matter of fact, it probably ain't no reason behind it because they're not gonna tell the damn court. They're supposed to tell them 5 days ago. They still ain't tell them nothing yet. What's really tea?
Defendant's decision. Interesting. Curveball. They're saying it's not up to Melly, but the judge was saying it is.
The judge did say it is.
I didn't expect that. The United States Supreme Court has recognized that the Sixth Amendment right to counsel is circumscribed. I thought that was about to say circumcised, and I was like, what am I reading? In certain situations. See Wheat versus U.S. a 1988 case explaining that the Sixth Amendment right to counsel is premised on the right that a defendant is entitled to receive a fair trial through the adversarial process, and the relationship between the counsel and defendant must give way to that right. So this whole paragraph is basically the state trying to get around Melly's Sixth Amendment right. That's what you just read there. They're saying the Sixth Amendment right to counsel is limited, and they cite whatever this case is. So there we go. The United States Supreme Court also explicitly rejected the argument that a waiver of the conflict cures a violation of the Sixth Amendment. To the contrary, courts have a legitimate interest in ensuring the criminal trial is conducted within the ethical standards of the profession. Wheat at 161. Therefore, the rules of professional conduct, including those rules of the State Bar Association, which govern attorneys' conduct, are of paramount importance and should assist in informing the judiciary about how to proceed. So now they're bringing up the State Bar Association, hinting that if Raven Liberty doesn't withdraw, she can get in trouble with the state bar, right? They're trying their hardest to get Raven Liberty off this case. That's all I'm seeing here. At issue here is alleged that the alleged criminal conduct involving Raven Liberty, one of Demons 4 attorneys, clearly after reviewing the search warrant and camera, there can be no doubt that an actual conflict is present, squarely involving the personal self-interest of Miss Liberty. Moreover, if this alleged conduct, if true, involves multiple violation of the rules regulating the Florida bar. I knew it. Yep. They don't even want Raven Liberty to be a f***ing lawyer anymore. Or at least they want her to be punished for whatever she did. Or they're accusing her of doing something with the witness tampering. Citing a night.
I'm trying to figure out, like, if she did something, like, is them saying what she did gonna affect the case? Is that the reason why they don't want to say what she did or what they're accusing her of? But it's blowing me, because last video we seen, Judge simply looked at Melly and he was like, bro, it's your choice. I'm gonna give you the opportunity to let me know what you want to do. If you want to get rid of her, just get rid of her. If you don't, it's that. We cool with that. But now when you look at this, they basically trying to say it's not up to Melly. It's up to us. And we finna go against your right. Nigga, forget your right. Yeah, we finna go ahead and exclude that. You dig what I'm saying? And matter of fact, we finna try to get her license revoked. My nigga, what's really tea? Is somebody gonna let me know what's really going on here? Because it ain't making sense.
Free case listing numerous rules involving dishonesty and criminal conduct as examples of unethical conduct prohibited by the Florida bar. 60% of you aren't subscribed. Come on, hit the subscribe bell. The 4th District Court of Appeals has also recognized the superior authority and insight inherent in the trial court's purview to reject a waiver of conflict. Court's authority to reject a defendant's waiver of attorney conflict based on counsel's prior representation of a state's witness. In fact, the 4th noted in a footnote that if the lawyer's conflict encompassed counsel's self-interest, a waiver is precluded as a matter of law. Therefore, the 4th DCA approved of the rationale in United States v. Fulton, where the conflict involved allegations of criminal conduct by defense lawyer, regardless of whether the lawyer is ultimately found innocent. So the 4th DCA doesn't care if the lawyer ends up being innocent or not. This was all
crazy.
Worded very strangely. I can't even dumb that down. Okay, here we go. In Fulton, the court stated, second, even if the attorney is demonstrably innocent and the government's witness allegations are plainly false, the defense is impaired because vital cross-examination becomes unavailable to the defendant. Ordinarily,
Bruh, this is the weirdest cheat code bull crap I ever heard before. So basically what they telling them is, yeah, Judge, we understand you ordered us to tell you, but guess what? We're not going to tell you shit. Matter of fact, not only are we not going to tell you shit, we're actually going to accuse her for something. And guess what? Even if we are wrong, she can't tell us shit. You feel what I'm saying? And as a matter of fact, when we come back to court, have some cookies and milk on the table for us, because we finna come through this bitch like Santa Claus. We handing out presents. And the present we got for her is, you're fired.
a witness's blatant false allegations provide a rich source for cross-examination designed to cast a doubt on the witness's credibility. But when allegations are against a defense attorney, this source cannot be tapped. So this has to do with witness credibility and cross-examination and bullshit like that. The trial court is obligated to protect the truth-seeking function of the proceedings by considering if the defendant has effective counsel, even where defendant wishes to waive the conflict. State hereby submits this memorandum of law. So it sounds like the state is just trying their hardest by citing cases and 4th district rulings that basically say Raven Liberty is not allowed to be Melly's lawyer no matter what. So they're trying their hardest. Where's the fucking search warrant? Have they handed this over yet? That's the real question here. Oh boy, here we go. State's motion for protective order. On December 27th, defendant filed a motion for hearing to determine potential conflict, blah, blah, blah. State hereby requests this honorable court enter a protective order restricting the disclosure of the search warrant, whether redacted or unredacted, to anyone outside the defense team or defendant due to the nature of the investigation and due to it still being a pending investigation at this time. I'm starting to hate Miss Alexander Buckaloo, dude.
So instead of submitting what they told them to submit, they do something else to cover their ass. Like, wow. What the hell? Are you serious, famo? Sure, they just forgot everything the judge asked her to do. We're going to put in a motion to not give them the search warrant. It's crazy work.
What? It's a search warrant. How is this going to fuck up an investigation? It's already a known thing that her phone is being searched related to an ongoing investigation. In Barfield versus City of Fort Lauderdale, the court held that under Florida law, active criminal investigation information is exempt from public disclosure until the investigation is concluded. As discussed, Florida Pub, 1998 case, an executed search warrant and accompanied material is exempt from discovery and public records law pursuant to section blah, blah, blah. Okay. As such, the state requests such a protective order preventing the dissemination and or discussion of the Apple iCloud search warrant regarding attorney Raven Liberty with anyone outside the defense team of lawyers. I am mind blown. There is no way this judge is not going to be pissed about this, right? I got to see what people are saying on Twitter about this. He ordered her to hand over the search warrant yesterday, and she didn't. She just requested a protective order. So she disobeyed a court's order. That's what that sounds like to me. Wow, really seeming like they were doing all this in effort to punish Melly even more because they figured he wouldn't let her go as his lawyer. Honestly, I thought he should get rid of her. I kept saying that, but I don't think he's going to get rid of her. So they're just predicting that if Melly doesn't get rid of her and he just waives a conflict and he's like, yes, I'll let her be my lawyer still, that she's required to withdraw. Judge going to be mad. Oh, here we go. Perfect tweet right here. State of Florida willingly and intentionally defying a court order. Hopefully the judge has some balls and admonishes the state for their bullshit. Wouldn't put it past Buckley to file another appeal because she can't handle losing. It's only going to hurt the state's case. Incredible. I'm loving that tweet. That's pretty much what I was thinking here. How is it going to impede the investigation, and how can evidence be destroyed if it's being handed over to the fucking judge? This is ridiculous. So what's the repercussions of the search warrant not being handed over? Shout out Bryson Paul. These are all his tweets, by the way. It's a motion, so I don't believe.
Good question. What are the repercussions of the search warrant not being handed over? What is it? I'm trying to figure out, what is the judge going to say? What is going to happen? Because boy, oh boy, oh boy. State already know they did some foul stuff. Like, so a protective order for what? How is this going to ruin anything? I'm confused as hell.
There's no repercussion for it. It's just up to the judge to rule. Sounds like Fulton County DA. They want her off the case bad. Wow. Turn the search warrant over. Ignoring court orders by the state. Color me shocked. Big slap in the face. I mean, yeah, everyone is pretty much saying what I was saying. I didn't even know that there was discussion about any of this. Okay, I've got it. The law is what the prosecutors say it is. Your rights are what the prosecutors say they are. Under our Constitution, judges are optional. An order by the judge is optional to the DA. Got you. Yeah, I would imagine the judge is going to be very pissed about this, and I can't wait to see what he says.
Yeah, that's the funny part. When we do see what the judge say, it is going to be hilarious, chat. It is going to be hilarious. Yeah, y'all gonna see that video ASAP, man. Yeah, I know the judge is not going to be happy about this, bro. You know, y'all just been disobeying the court orders for a little minute, and I think the judge is about fed up. So, good luck with that one. Judge gonna look at your protective order like, you don't get this shit out my damn face. Cause at this point, you're a little bit too hot out here, man. You need some milk, man.